The Supreme Court is now being asked to weigh in on whether a state can lawfully implement what's known as a Second Amendment Preservation Act, essentially a law designed to turn a state into a Second Amendment sanctuary. But there's been a significant delay in the case, largely due to the Trump administration, which has yet to move forward with a clear plan on how to handle it. Let's break down exactly where things stand. Before we get into the details, if you'd like to support the channel without spending a dime, the easiest way is to hit that subscribe button. It helps us reach more viewers and grow the community. Also, feel free to leave a supportive comment below. Those positive interactions help tell the algorithm this is content worth sharing. Now onto the case itself. This is a major Second Amendment challenge that has once again made its way in front of the U.S. Supreme Court. It centers on Missouri's Second Amendment Preservation Act, often referred to as SAPA. You may remember that we've discussed this case previously, especially after the Supreme Court issued an 8-1 decision denying a stay that would have protected Missouri's SAPA law while the legal battle played out. Following that denial, the case was sent back to the Eighth Circuit Court of Appeals. The Eighth Circuit recently issued its ruling, and they sided with the then Biden administration. The court found Missouri's SAPA law to be unconstitutional, arguing that it violated the Supremacy Clause by attempting to override federal law. In response, Missouri filed a petition asking the Supreme Court to take up the case and overturn the Eighth Circuit's ruling. However, the process has hit a roadblock. Even though the Trump administration now has the authority to steer the case, they've opted to delay. They claim they're still reviewing their options and have not yet determined how they want to proceed. For those unfamiliar with the origins of SAPA, Missouri enacted this law in 2021. It was designed to reflect the state's interpretation of the Second Amendment and to limit cooperation with federal enforcement of gun control laws that the state deemed unconstitutional. Under SAPA, Missouri law enforcement and state agencies are barred from assisting federal agents in the enforcement of such laws. The statute also includes a civil remedy, allowing private citizens to sue Missouri officials who cooperate with federal authorities in enforcing gun laws that infringe on Second Amendment rights. This setup is similar to the approach Texas used with its abortion law, SB 8, which led to the Supreme Court's review in Whole Woman's Health v. Jackson. The structure of both laws makes them difficult to challenge because state officials aren't directly enforcing the law. Instead, private individuals are the ones bringing civil lawsuits, making it impossible to issue a blanket injunction against the state, its attorney general, or other officials. To block the law's enforcement, you'd have to get an injunction against each private party who might bring a suit, an incredibly difficult and complex task. In this case involving Missouri's Second Amendment Preservation Act, the federal district court initially ruled in favor of the Biden administration, striking down the law entirely. Missouri appealed that decision to the Eighth Circuit and requested that the court pause or stay the lower court's ruling while the appeal was being reviewed. However, the Eighth Circuit denied Missouri's request for a stay. That denial led Missouri to take the matter to the Supreme Court for the first time, asking for an emergency stay to keep the law in effect during the ongoing legal battle. The Supreme Court, however, rejected the emergency request in an 8-1 decision. Justice Clarence Thomas was the sole justice who supported Missouri's request. After that ruling, the case returned to the Eighth Circuit, where the court held expedited oral arguments. Ultimately, the Eighth Circuit ruled in favor of the Biden administration, once again striking down Missouri's SAPA law in its entirety. Now, Missouri has formally filed a petition asking the Supreme Court to review the case on its merits. In the petition, Missouri presents 3 central legal questions it wants the court to address. 1. Can federal courts question a state's motive for exercising its powers under the 10th Amendment? 2. Does the Constitution prevent a state from using its 10th Amendment authority simply because the state believes a federal law is unconstitutional? 3. Under Ex parte Young, is a state official a proper defendant just because they are affected by a statute, or must they also have the power to enforce that law? In its argument, Missouri claims that this case sets a dangerous and unprecedented legal precedent. According to the state, no federal court had ever previously blocked a state from exercising its 10th Amendment authority based solely on the reason the state gave for doing so. But that's exactly what Missouri says happened here. The Eighth Circuit didn't object to what the SAPA law actually did. It objected to why the Missouri legislature enacted it. Specifically, The court struck it down because the legislature included findings stating that some federal gun laws violate the Second Amendment. Missouri argues that this logic is flawed. The Eighth Circuit admitted that the same law could be legal if it had been passed for a different reason. For example, if Missouri had said it was simply choosing not to allocate state resources for policy reasons rather than making a constitutional judgment. In other words, the Eighth Circuit's decision wasn't about the law's function, but about the legislature's opinion. Missouri warns that this reasoning not only contradicts established constitutional principles, but also opens the door to broader judicial overreach. By focusing on legislative intent instead of the actual content and effect of a state law, federal courts could end up invalidating state laws based on political or ideological disagreements rather than legal merit. One of the key points Missouri raises in its petition is that the Eighth Circuit did not actually have a problem with the structure or potential function of the SAPA law. In fact, the court acknowledged that the way the law is written and how it might operate is legally sound. However, the court ultimately struck it down because of the underlying purpose behind it. Specifically, the judges took issue with the fact that Missouri's legislature based the law on the belief that certain federal gun laws are unconstitutional under the Second Amendment. Missouri argues that the Eighth Circuit effectively ignored well-established legal precedent by allowing state officials to be sued, even though those officials weren't actively enforcing the law. Instead, the court claimed that simply following the SAPA statute, essentially not cooperating with certain federal actions, was itself a form of action. So in this view, doing nothing was considered doing something. Missouri sees this interpretation as deeply flawed and legally unsound. Originally, this lawsuit was opposed by the Biden administration. But now, with the Trump administration back in charge, they control how the federal government chooses to move forward. Back in February, the federal government was expected to submit its response brief in this case. However, the Trump administration has since requested and received multiple extensions to delay filing their position. Just recently, only days before the extended deadline, the Trump administration was granted yet another extension by the Supreme Court. The new deadline to respond is now set for June 10th. At this point, it appears that the administration is taking its time and may be intentionally slowing the process down as it evaluates its approach. There's also an important connection worth pointing out. This case was originally brought by the state of Missouri, and one of the key attorneys involved in the appeal before the Eighth Circuit is now serving as the U.S. Solicitor General. That means the Solicitor General has direct experience with this case and a clear understanding of the legal arguments involved. Currently, the newly formed Second Amendment Task Force is believed to be reviewing the case closely. However, their strategy so far seems to involve caution and delay, rather than a fast or aggressive legal push. It's likely they're weighing options carefully to develop a strong pro-Second Amendment legal strategy. With someone as knowledgeable as the Solicitor General already familiar with the case, it's reasonable to expect that the administration is aiming for a favorable outcome, but only once the timing and legal posture are right. At this stage, the Supreme Court has already granted the Trump administration multiple extensions, each time based on essentially the same justification. And if another extension is requested, it's likely to be approved as well. From my perspective, it doesn't seem like the court is in any rush to move this case forward. As long as the administration keeps asking for more time, the court appears willing to allow it. Frankly, I don't think the justices are eager to take on another high-profile Second Amendment case at this moment. We've already seen them deny review in both the scoped rifle ban case and the Ocean State Tactical Magazine ban case. That sends a pretty clear message. They're not looking to weigh in on major gun rights issues right now unless absolutely necessary. The pattern is clear. Every time a deadline approaches, the Trump administration steps in and asks for more time. The next major date to watch is June 10th. While it's possible they could file a response by then, history suggests another extension request is more likely. What makes this case so important is that it centers on state-level sanctuary laws and how states can assert their rights when it comes to protecting the Second Amendment. But for now, it seems like the strategy is to keep things on hold. The administration may be waiting to see how other legal issues unfold, or how the Supreme Court handles other related matters before deciding how to proceed. As always, I'll be closely following this situation and will update you as soon as there's any new development. If you found this video helpful and want to support the channel, the best way to do that is by liking the video, leaving a comment, and subscribing. All of that helps signal to YouTube that this content is worth sharing with more people. Thank you all for your continued support, and as always, stay informed and stay engaged.